Hello everyone, this is Rajiv Khanna from immigration.com, the law office of Rajiv Khanna PC. This is our two-weekly telephone call, free community conference call. Everyone is welcome to join, ask your questions. Most people post them. You don't have to, but it makes it easier for us to know how many questions we have to answer. And if you have posted it and we know the answer, you're pretty much guaranteed to get a reply. That said, um, as you would have heard when you logged in, this is not an attorney-client relationship arrangement. We are just providing information. Um, all the disclaimers that are put in our introduction when you log into the conference call apply. I want to let you folks know that I have a very active Twitter account as well as YouTube, uh, Google Plus, LinkedIn, Facebook, Pinterest, and two apps, one for the Android, the other one for the Apple platform. Please feel free to join us there. From the Twitter account, yesterday people had been debating. I want to address those issues first. What is the status of the H-4 EAD regulations? Are they still stuck? Are we going to see anything? And the answer is we don't know. Um, as you folks know, those regs have been pending now for a long time. The last action on them was an invitation by USCIS for public comments. Over 12,000 comments were received, I think 12,600 something. That could be part of the reason why they are getting delayed, but it depends upon what kind of comments were received, how long it takes to address them. Pretty much they have to consider every comment that is received. Okay, so that could be part of the problem. I am not sure why we are getting delayed. Okay, we are keeping an eye out on it. If I can find something out, I will tweet it. I will have it sent on our apps as well. On our apps, if you have installed our app on your telephones, um, Android or iOS, we have the Windows application also coming out for Windows-based phones, probably in a couple of months at the most, maybe even earlier. So you will get a message from us about what's going on, or if you go to our website, all the latest updates are there. We'll keep an eye out on this. Next set of questions was received by me through email, and I've been kind of sitting on them for about a week, 10 days. My apologies. I thought I was going to be able to get to them last weekend, but it just didn't work out. So let me respond to it there, to these questions now. They are concerning Obama's immigration action. So first was, you mentioned that once someone has approved, he does not need to wait for, okay, so they're saying that under the Obama's proposed action, if you have an I-140 approved, you don't need to wait for 45 dates to be current. That's what I said. I think you misunderstood it. What I said was, what President Obama said was that we don't have to wait for the priority dates to become current. As soon as the I-140 is filed, you can apply for your 485. Whether you are EB2 or EB3 category doesn't matter. And that way you have your EAD and advanced parole early, as well as AC-21 right to change employment early. Okay, and it's not official now. It is merely an announcement. When do I think it'll be implemented? I actually had a very long discussion with a client of ours this morning. I wish I could have recorded that call, but that's a confidential call. We can't record it. But I explained to him that basically the Obama immigration action can be implemented in one of the following ways. The fastest method is if USCIS decides, okay, we can implement it with just a letter or a memo. If they do that, they could implement it overnight. There are other methods. The most delayed method is by formal rulemaking, which is what the government seems to be doing. It seems like they are going to go the rulemaking process for many of the provisions. I don't know which provisions will go which route, but rulemaking could take months. It could take 1 month, 2 months, 3 months more. Okay, so typically, technically, rulemaking has to be open for once the proposed regulation is published. I think it's 60 days for notice and comment. So it could be many months life cycle. But they can shorten it if the regulation is basically just an interpretation of the law, which it is. So I don't know how long it will take. It could be overnight to many months. The next question by another member of our community who had sent me a direct email. He said, I saw your radio show and you said that EB3 category who has an approved I-140 can file 485 without waiting for the priority date. That's correct. Does that imply that the principal applicant gets an EAD after 180 days of filing? The answer is the EAD comes right away. Just like you would if your priority date was current, when you file within 90 days, you get your EAD, technically. Okay. And therefore can work for any employer. You can work for any employer after 180 days as long as the jobs are same or similar, but the EAD should come earlier. Okay. Is this applicable to EB2 as well as EB3? And the answer is yeah, EB2 as well as EB3. One more thing I wanted to add. This client that I spoke with this morning had a set of interesting questions. He asked me, he says, Rajiv, if let's say the regulation that's pending for the H-4 gets passed, and then the Obama action also gets passed. So let's say my wife already has her EAD through her H-4. Will she also get an EAD when I file 485 for her and for myself? And the answer is you won't get two EADs. You can surrender one and take the other one. But yeah, you will be entitled to two different roads that you could take potentially. Okay. And with that said, let me now go back to our normal set of questions. Again, I'm going to go over the questions that I have marked as frequently asked questions first. Invite your questions or input on those, and then go back. In fact, I'm sorry, I forgot. Whatever I have discussed just now about H-4 regulation and about Obama's action, do you have any questions on that? Nothing new, but only questions on what I just discussed. If yes, press *5 on your phone. Any questions on Obama action or H-4? Okay, then let's go into the frequently asked questions first. First frequently asked question that I marked was changing from EB3 to EB2 category. How does that work? So the idea is once an I-140 is approved under any category, EB1, EB2, EB3, once the I-140 is approved, the priority date becomes the property of the employee. Whether the employee goes to work for a different employer, a different job, completely different job. You could go from being an IT professional to a civil engineer. Okay, completely different job. You would still carry your priority date. This is not AC-21. AC-21 requires same or similar job, but that also requires I-140 approval 485 pending for 180 days. This is not that case. The priority date transfer from EB3 to EB2 requires only that the I-140 is approved. Okay, so this Abshu wanted to know, I have my I-140 approved under EB3. I have a master's degree from an accredited US university. Can I change it to EB2 now? And the answer is yes. If you get a job with the same employer or with a new employer that requires a master's degree or bachelor's plus 5 years experience type of qualifications, and your priority date will remain the same. The difference between AC-21 and priority date carryover is this. In AC-21, you don't have to refile the green card. You can take the whole green card and take it over to a same or similar job if your I-140 is approved and 485 has been pending 180 days. But in the priority date transfer, you carry forward nothing. You only carry the priority date, and it can be ported from EB3 to EB2, EB3 to EB1, EB1 to EB2, EB3, doesn't matter. Okay, and there is no requirement that the job that you are filing for is same or similar. So that's the difference between AC-21 and priority date transfer. Guys, no new question. Anybody has any question regarding what I just discussed? Press *5. Any question regarding what I just discussed? Okay, so one of the questions, ancillary questions in this, let me just make sure. Yeah, I think we're okay. All right. One of the ancillary questions are what kind of problems I can have, and the answer is that's difficult for me to predict. Whatever problems people can usually have in green card process will be the same for you. Um, I can't think of anything very, very special that's involved in this that would take you beyond the ambit or the circle of normal problems. Okay. Um, and a kind of a corollary of this question is what is the procedure for porting a priority date from one I-140 to another? And the answer here is priority date transfer is supposed to be automatic. You really don't have to do anything about it. And it is my understanding what USCIS does is they do periodic sweeps, in fact, several times, I think a month, where they do a sweep like a query of their database, and whoever is entitled to whichever priority date at the earliest, they automatically assign that to you. So if you have one I-140 approved earlier, another I-140 going on or approved, they will automatically assign you the earliest priority date to which you are entitled. That may or may not reflect in your approval though. Okay. So just because it does not reflect in your approval doesn't mean that you're not going to get the earlier priority date. You can confirm it by opening a service request. You can confirm asking them what is my priority date. Okay. So GC Helps asked us, I have two approved I-140s in EB2 from two different companies, same A number. One with 2009 PD, the other one with 2011 PD. Okay. 2009 case was approved, so we could not port the date. So the answer is you are eligible for filing 485 automatically when the 2009 date becomes current. All you have to do is attach a copy of the earlier approval notice with it, along with the current approval. You should be fine. Anybody has any questions concerning this issue I just discussed, press *5 on your phone, please. *5 on your phone. No new issues, just these. Okay. Let's go on to the next question. Next frequently asked question was filing PERM using experience gained with the same employer. The way it works is normally you cannot use as a prerequisite qualification for a job experience that you gained working for the same employer. To give you an example, let's say I joined an employer as a software engineer and I worked 3 years as a software engineer. When I joined the employer, I had zero experience. I'm right out of school, master's degree, and all 3 years experience with the same employer. So when I file my PERM application, can I require that every applicant must have 3 years experience, at least with a master's degree? And the answer is no, unless you meet the following requirements. Okay, what are the following requirements? If the job being offered to you as a green card job is more than 50% qualitatively different, quantitatively more than 50%, qualitatively different than the job of software engineer. Let me explain. So if you joined as a software engineer, you got 3 years experience. The next job being offered is a project manager, for example, where more than 50% of your time is spent in managing projects, not in hands-on architecture or development. That's a qualitatively more than 50% different quantitatively job. So both quality and quantity are different. Now you can use the experience you gained because the job being offered is different than the job that you had before. Okay, and there's a very, very simple common sense reason for it. What is the common sense reason? When you joined this employer, you had zero experience. Okay. After 3 years, the employer claims that they require 3 years experience for the same job. USCIS would want to know and Department of Labor would want to know what changed. There's actually another provision in law that talks about unfeasibility of being able to provide that experience to another US worker. So if there is such a requirement, that is hardly ever invoked. Most people get offered a job that is more than 50% different. Okay. Now, Moss's question is, Moss says, I'm working for this employer for 3 years. If I leave the current job and go to another company B and work for a few months, can I then use the experience gained with employer A and come back with A? The answer is no. I don't think so. I think you will still need a substantially different job. So it is better to be offered a substantially different job and apply with the same employer, because working for a few months for another employer will not work. However, if you go from employer A to employer B and employer B does your PERM application, then there is no problem. You can use the experience gained with it. That's quite obvious. Okay. Does anybody have any questions on filing PERM using experience gained with the same employer? What I just discussed. No new questions. Any questions about this? Press *5 on your phone, please. Okay, no new questions on this issue. Let's see if we have any other frequently asked question. Okay, we do not have any other frequently asked questions. So now I'm going to start answering the questions in the order they were posted. Chini 2012, working for company X as a software engineer. Green card is I-140 pending. If I change title from software engineer to senior software engineer, is there a problem? Job duties are 100% the same. I prefer not to change these titles, but really, if you have to, then I think you'll be okay as long as the job description is 100% the same. Okay, I think you'll be all right. I prefer not to, and I would like to know the reason why they are giving you the title of senior software engineer. By the way, Obama's announcement on 21st November also said that they intend to make this natural progression in careers okay for green card purposes. So maybe we'll see some better common sense statement of law that helps people like you. But right now, I prefer not to change it, but it's okay to change if the job description is substantially the same. And if it's exactly the same, I think you are pretty safe. Murali Krishna says, my current H-1B expires in June this year, 2015. How can I extend my visa in any category? Well, people go to OPT or CPT. What they do is they take an admission in a graduate program and they go to curricular practical training. But remember, the following requirements should be kept in mind. Number one, CPT should be given only for a graduate program. You can get CPT in the first semester. It's legal. But it must be given only if the program is a graduate program. Number two, the CPT must be integral, necessary for the program. So USCIS will often go to the website of the school and say, oh, the school website doesn't say that the experience is necessary. Okay, so it must be integral. Third thing, the university that gives you the CPT or the school that gives you the CPT must enter into a cooperative agreement. It's a one-page agreement, usually quite simple, with the employer who's going to give you practical training, which is actually a job. It's like a job. Basically, you're doing a job and you're getting school credits for it as well. And the last thing that I recommend, go for an accredited degree only. Don't go for an unaccredited degree. I think it's not such a good idea. That's the only option I can think of. People can go to tourist visa. You can go to student visa without CPT. These are some of the things that people try. Okay. Let's go on to the next question. RK010172. RK is a Indian national with a green card since 2002. Oh, I remember reading you. I think you had sent me an email also. You went through a bunch of litigation rounds with the government. They are taking away your green card because they believe you were not admitted for permanent residency and because of moral character issues. Now, look, yours is a very complicated case. There is no way I can address it in a community conference call. You can set up a consultation with us. I don't think I'm going to be able to do much for you. Okay? I've looked at your case. I remember even reading it. And I think there is some misunderstanding of something called Commonwealth rule. First of all, I'm not aware of any law, last 22 years that, not 22, more than that, almost 30, that I have practiced law over a couple of decades of which were in immigration law. I have not seen any law that allows you to come into the United States when you're not a citizen of Canada and stay here indefinitely without having the problem of 310 bar. It looks like you had a bar. Okay. So I don't think I can do anything for you, much though I would like to advise you, but I don't think I can help you from what I have seen so far. So my advice would be don't waste money on me. You can talk to other lawyers. I just don't feel that there's anything I can do for you. I know that you are, I saw your case before, I remember. So SHD is Satish, who says, this is a follow-up question. He's got a friend who had a travel permit and is going through some health issues, and the travel permit is expiring, I think, January 30th. Let me confirm that. January 30th, re-entry permit. And the green card is expiring in February. So his question is, I told him that it's difficult. It's a very difficult circumstance. Oh, I'm sorry, somebody raised their hand. Let me get that first. New Jersey, you had a question about something we have discussed. Go ahead. New Jersey.
Yeah. Can I talk?
Yes, go ahead.
Okay, I just want to find out if I can apply for the citizenship again or not.
You are the person with all those the Commonwealth rule issue, right?
Correct.
Okay.
Correct.
The answer to your question in the abstract, ma'am, is this. There is no limit on how many times you can apply for naturalization.
So, but after my denial also from the judge, from the district court, can I still apply? Will they be denying it on the same grounds, or I mean, what are the chances?
I do not know what the order says, what the order of the judge says. If the judge says you are subject to the 310 bar and you were not, you were not given a green card validly, you cannot apply for citizenship, because if your immigrant visa itself has been challenged and held to be invalid by the judge, you cannot apply for naturalization. I don't know what the order of the judge says.
Then in that case, can I apply through the naturalized citizen spouse?
I don't see why not. You would still have the problem of the 310 bar, but you can certainly apply through a naturalized spouse, yes?
What are my chances?
I do not know the answer to that question. I don't know your case in detail. By the way, if somebody applies and they have a 310 bar issue, the 310 bar can be waived if there is some extreme and exceptional hardship to your citizen spouse. So at least there is some fighting chance there. If you can demonstrate some hardship to your spouse, you will be able to get your green card if you are able to get the waiver of the 310 bar. Because I noticed that in your background when I read your email. You sent me an email, I remember
that. Right.
Okay.
So green card is there since like 15 years, I guess, less than that. But the citizenship is a challenge right now.
Green card is 15 years? I didn't understand that.
Yeah, because I'm a legal permanent resident since 2002, right? So
yeah, no, but
almost 12 years I have been on green.
But they said that, look, ma'am, that's the reason I told you that I will not be able to deal with it in this conference call. I would have to look at all your paperwork starting from beginning to the end to give you any intelligent answers. Okay, right now I am floundering because I have really not looked at your paperwork. I've heard what you said. I don't know what the court said. I don't know what the USCIS said. So here's what I advise you. If you have good, competent lawyers, stick with them. If you're unhappy with them, go ahead and approach us. We'll set up a formal consultation. I'll spend a few hours going over your paperwork, see what we can suggest to you. However, generally speaking, naturalization cannot be applied if you don't have a green card. And green card can be applied, and ultimately disqualifications can be waived if there is hardship to your spouse. Okay, let me go on to the rest of my questions. I gotta go
on. Okay.
All right. Sorry, folks. There are some things we just can't address in a call. We can answer simple questions and even complicated questions if it doesn't require looking at your documents and details. Okay. Next question is I was talking about the re-entry permit. So first thing I told you was that it's a bad idea because re-entry permit, once it expires, then you don't have a green card anymore. Okay, the moment it expires, your green card is gone. You did not enter into USA during the time permitted, unless you've been back in the US in the last 6 months before the expiration, or the last 1 year before the expiration. So then I think we discussed, and I told you that go ahead and get a travel letter from the consulate if you can convince them that there was a genuine reason for not being able to travel. Now your questions are whether he has to carry traveling permit after the expiration. He has to get the travel permit or the travel letter after the expiration of the re-entry permit. Okay. Is it okay to travel after expiration of re-entry permit and within 1 year of last re-entry? It's a very interesting question. I haven't looked into it, Satish. I don't really know how that would play out. My guess is, this is just a guess, you cannot hold me to it. My guess is there is some argument here. Hey, I was in the US within the last 1 year. You can't automatically take away my green card just because my re-entry permit expired. I think that's a good argument. You may not even need a travel letter in that case. But what will happen when you land? Are they going to give you hassles? The law is that if you land at the airport with a green card, they have to let you in. They can confiscate your green card, put you in proceedings before immigration judge, but they cannot not let you enter. They have to let you enter. Oh, there's a raised hand again. Just give me 1 second. Somebody raised their hand. I'm not going to be able to get to your case, man. New Jersey, I can't. I can't discuss it here. Sorry. Okay, so going back to the re-entry permit issue, what would I do? I would prefer that you come before the 30th. Really, that is the right thing to do. And I think that 1 year rule may protect you, but I can't swear to it because I haven't looked at this issue. Okay. Robert Mart says, I'm in USA since August 2010 on H-1B, which is good till 2017. I have an approved I-140 EB3 with March 2013 priority date. EVC model work, same client, 2.5 years. I want to travel to India. My visa is expired. If I don't have a client letter, will there be an issue in visa stamping? Almost certainly. Almost certainly. Because consulates are not known for, ma'am, New Jersey, you have to stop raising your hand. I'm not going to be able to get to your questions. They are too involved, too intricate. I cannot give you any information without looking at your paperwork. Put your hand down, please. Okay. So almost certainly, in my view, you will have a problem getting a visa stamping. If you are exceptionally lucky, you may not have a problem. Okay. There are two raised hands. One is from New Jersey, and I'm putting your hand down again. Do not raise it again, please. And there's another one from Campbell, California. California, you have a question. Go ahead, please.
Hi, Rajiv. My question is that I'm working on a H-1B visa and my visa is set to expire.
Stop. No new questions. No new questions. That's in the end. I'll call upon new questions. Okay. Right now I'm just doing the questions that have been posted. I'll call for new questions. No new question right now. Kansas, if you have a new question, put your hand down, please. Press *5 again. Put your hand down. I see again 2 raised questions. New Jersey, you put your hand up again despite my request not to. I'm disconnecting you. I've disconnected New Jersey. They will not listen. I need to maintain a certain order, otherwise I'll never be able to get anything done for most of you. Okay. Let's go to Kansas. Kansas, no new question. Do you have a follow-up on something I've discussed?
Yes, Rajiv, I'm GC Helps. I think you answered my question on 140. Basically, my question is, amendment is required, or basically for putting the date, do I need to amend my 140, or can I just file 485 with the service request?
You just file your 485. You file the 485 with both the I-140s included, copies of both I-140s.
Okay, I don't need to amend now, right? 140 amendment is not required.
I have never done it. That's how we do it. If somebody else is recommending something else, they must have a reason for it. We've never done it. You can also double check with USCIS customer service. And while you are doing it, you can double check what priority date they are assigning to you. They should assign to you the 2009 priority date.
Okay.
All right?
Okay.
Good luck.
Okay. Thank you.
You're welcome. Okay. Let's go back to our queue. Okay, so we talked about the visa without an end client letter is going to be very difficult. Not impossible, but very difficult. Samir had a question. What are the steps for opening a service request with NVC? NVC, usually we just send emails to them. There is no service request process. We just send emails to them, and you can also follow it up with a phone call. It will take you forever to get through, but if you do get through, and when you do get through, you'll be able to talk to a live human being. Next question, H-1B after 6 years, and this is IMMI Help Pre-Q. Got H-1 transferred to employer A in April 2012 during 5th year of H-1B. 6 years would have completed by 2013. So by error, he got an H-1 for more time than was due to him. Instead of giving him 1 year, they gave him 3 years. He got the stamping on that also. But not to overstay, he returned to India in Feb 2013. That's a good move. That's the right thing to do. So, will there be a problem at the port of entry? Do not use the current visa, which has been given in error. If you do, USCIS and the Department of State can call it fraud, misrepresentation, etc., etc. Don't do that. You should extend your H-1B based upon the PERM. That's the right thing to do. What can you do to know the status of the PERM? Well, PERM filings are done online. Your lawyers can tell you by looking at the screen on their filing what is going on. If the PERM processing doesn't go through, you can make an appeal, file an appeal against the PERM denial. And while the appeal is pending, which is three and a half years, you can get H-1 extension for 1 year and start another green card through another employer. That H-1 extension does not have to come through the same employer who filed the PERM application. Okay. Next question, IMMI Help 2015. This is a very problematic issue. Okay. When you have any implication of fraud and misrepresentation, I actually have a video on this which goes into much greater detail, but suffice it to say, when there is a fraud implication raised against an individual, they can be, if they are found to have committed fraud in that application or during the adjudication of a subsequent application, that issue will come up and it's brought up and the government notes, oh, you committed a fraud in 2009, you will be barred from entering USA forever. It's a permanent bar from entering USA, and getting a waiver is quite difficult. There is something called 212D waivers, which are very short-term temporary waivers for short visits. Getting a waiver through family members, immediate family members, is a little bit, it's a possible solution, but it's not an easy solution either. So fraud and misrepresentation is a very serious problem. In fact, even if there is an implication raised, you said they did not mention anything about the FNM, fraud and misrepresentation. I do not know I'll have to look at the papers. And again, this is something I cannot comment without reviewing the entire case. What did the USCIS allege in the RFE? How did the employer respond? If they did not respond, what was sent in? You said they did respond. Okay. A notice of intent to revoke was sent. So I need to look at the notice of intent to revoke, then I need to look at the final revocation. Okay. So I think the best thing you can do is, if your lawyers are competent, raise these issues with them. If you are uncertain or you need a second opinion, approach us for a formal opinion. It will take a couple of hours, and I will take a look at the paperwork. I can't guarantee that I'll have a solution for you, but at least I can tell you what I see as the potential issues. Okay. So question for mom. This is a question for mom based upon a green card filing. Mom comes and forth a lot. So can I apply for citizenship for her? That's a difficult question to answer. The reason is because she doesn't have health insurance here or any income. The problem is immigration to USA presupposes that you are going to live in USA permanently, not just visit USA. So first of all, USCIS can definitely make an issue of it. They can create problems. They can say that you have actually, your mother has lost her green card by not making USA her permanent home. In addition to that, make sure that she meets the requirements, which is 30 months physical presence in USA, no stay outside USA for a year or more, and if there is a stay of more than 6 months in any 12-month calendar period outside USA, you must have a good explanation for it. So again, in the abstract, I can only give you an abstract opinion and an abstract statement of the law. That's all I can see judging from what you're telling me. Okay. Will you get naturalization? I do not know. Will she lose her green card? I do not even know that. Okay. Next question is from an old client of ours. Hamid, by the way, if you're an old client, you always have access to us. Just drop us an email. You don't have to post here. I like to believe that we are very courteous to our clients, old or new. So just, you can always contact us. And by the way, naturalization security tests or security investigation can be a little bit tougher than the green card. And that the time period that you mentioned, that USCIS is required to adjudicate your application within 120 days, different courts have taken different position on this. The consensus of the opinion seems to be the 120 days begin only after the security is clear, not before. So I would suggest you wait. We can try to help you, but there's not much we can do more than what I'm going to suggest to you. We can take over the case, we can charge you money, but I think you'll waste your money. What I think you should do is first contact your congressman. Okay. Contact your congressman, ask them what the status of your application is, and then get back with me. You can post here because this is an easy enough issue to deal with. Let's see where the application is stuck. If it is indeed just in a security clearance phase, hopefully it will clear. Government's aim is, I don't know how far they're successful, their aim is to clear all applications within 6 months. That's their aim. So if it goes way beyond 6 months, maybe you can think about filing a lawsuit. I don't normally recommend lawsuits in delay cases unless there is a real good reason for it, or unless the particular area of the country where you are, courts are sympathetic towards delays. Like in DC, a delay case, I remember a case, we did a bunch of delay litigation. Some of them we won. But there's a case that is cited a lot. I forget the name of the case, but it was an issue about Native American tribes' certification as a Native American tribe, which then gives them the right to open a casino. And the application was delayed by Bureau of Indian Affairs, BIA, Bureau of Indian Affairs, by almost 10 years, and the DC court said that's not unreasonable. Okay, so delays are not usually an easy case to win. I would suggest you go to your congressman first, and let's regroup if that is not satisfactory after you've done that. That's free, and they are quite effective in finding out the status of cases. Next question is Helix 113, currently in 4th year of H-1B, passport expiring. Oh yeah, in his case, his passport is expiring and he doesn't want to do mandatory military service. Can he stay in USA? Look, without a passport, I do not know if you can stay in the United States. I don't think you can, but I haven't looked at the law specifically. Often I don't know the answer. But many years ago, I would say a good 20 years ago, we had a client who was from Greece, and he did not want to serve in the Greek army because apparently the Greek army has a very bad reputation for certain things. and he didn't want to go back. And I remember being able to get his green card based upon an expired passport. So he did get his green card through the expired passport. I don't know if that's legal or illegal. I cannot give you the answer. I wish I had better answer for you. Somebody should sit down and research this issue for you thoroughly. I think you need a passport to maintain status in the United States. Drew says, I got my green card a couple of years back in 2011. I have to go to India. I might be gone for more than 6 to 8 months. I think you should get a re-entry permit, Drew. Filing for a re-entry permit, all you have to do is apply for it before you leave. Okay, make sure you're in USA when you apply for it. It does not break your continuous residence. Just applying for or being issued the re-entry permit does not hurt your citizenship. Okay, if I apply for the re-entry permit and do return in 1 month, does that hurt my continuous requirement? No, no. Applying for it has no downside that I can see, other than losing money. Shuklaji wants to know, I had discussed about L1 visa a few months back with you. Sandeepji, I don't remember our discussion. I had opened a company in the US related to my Indian company, and you want to apply for L1 visa, and you read about EB1C. You see, EB1C is definitely an option, but the problem is it takes time. Plus, your company in USA must have been doing business for 1 year before you can apply for EB1C. EB1C could take anywhere from 6 months to a year after you apply for it, after your company has been doing business here for 1 year. And you want to know how to get started, what our fees, etc. are. Well, if you go to our website and look at the top ribbon, the fees are right there. I'm clicking on it. If you follow it, our fees are right there, and the L1 fees are included. What happened to the L1 fees? H1. Oh, that's odd. Oh yeah, they're right here. L1 on the right-hand side of the column. All our fees are published. We publish all our fees. We make sure that people know what we are going to charge. So here you'll see our fees. And you're welcome to send us a message through the contact us form or to firm@immigration.com or to me directly, help@immigration.com. Okay, we can take it from there. Next question is from Banyan Tree. 2 questions. In the Form I-140, Part 4, Question 6, has any immigrant visa petition ever been filed? It was actually filed by a previous employer, which was denied. USCIS has raised an RFE under the current I-140 for visa extension. Okay, you're doing an H1. For employer-employee relationship. Okay. What will be the impact of the visa extension if the RFE is denied? Will I be able to switch another employer in the meantime? Well, there are many things that are not clear from your response. Are you on the phone right now? Press *5. If you are here, Banyan Tree, there are too many things I don't understand about your case. Press *5 if you're here. Okay, you're not here. Well, I can give you a generic answer. First of all, if any one I-140 remains unrevoked, you can keep getting H1 extensions on a 3-yearly basis for any employer, not just the one who got the I-140 approval. But if the I-140 is revoked, you can't get H1 extensions beyond what has been given to you, unless you have another way of qualifying for it. So an approved I-140 will get you indefinite H1 extensions. Second, in order for a second extension or transfer to be filed, you must be maintaining H1 status. If your current H1 has expired and then this case gets denied, you will have to leave USA. An employer can file for your H1, no problem there, and you come back using your H1 extension and visa stamping. Okay. So, but if you lose status while you're in USA, getting it back within USA is unlikely. You probably will have to travel outside USA. Okay. Somebody asked a question from Monica, and Monica posted this Monica is a member of our team. In fact, I call her our CTO, Chief Technology Officer. Somebody's on O3 visa, how do I work? Well, if you are qualified for an H-1B, which is you have a bachelor's degree in a professional discipline, for example, Bachelor in Liberal Arts is not professional, Bachelor's of Arts in Economics is professional because it's in a specific subject. So if you have a specific professional degree and you get a job in that field and the employer is willing to process the paperwork and willing to pay the right salary, they can apply for H-1 on April 1st, and probably there's going to be a lottery, and if you get through the lottery, you can then start working on October 1st. Okay, how hard it is, I've just outlined to you the problems. As long as the employer is willing, you are qualified, and you get through the lottery, it's not hard. Okay. Next question, again, somebody sent directly to Monica. Form I-140 for EB1C category was denied. We don't have the letter yet. We never received the RFE. What do we do while we wait for these letters? You did not file a 485. And your E2 visa is also gone now. You will be out of status from the date your E2 visa or E2 I-94 expired. Okay, I can't give you good recommendations since we don't even know what the RFEs are all about. Wait until you get the RFEs, have them reviewed by your lawyers. If you are happy with what they suggest, go ahead and take their recommendations. If you want a second opinion or you want us to take over the case, set up a formal call with us, formal consultation. I can't comment about what is the best methodology to follow for the future. But I do want to warn you, from the date your I-94 expires, if you stay in the US 180 days and there's no resolution, you are subject to 3-year bar. So be careful with that 180-day period. It doesn't mean you're allowed to stay. It just means that you're out of status as well as unlawfully present. And that can create issues after 180 days automatically. Okay. Anybody who has follow-up questions on any posted questions, press *5. Anyone who has follow-up questions, no new questions, follow-up questions only. Once I'm done with follow-up questions, we'll start on the new questions. Okay, I have 3 people with follow-up questions. I'm going to talk with you in the order you called into the conference call, guys. Let's start with Illinois. Go ahead, please, Illinois.
Yeah, my question is regarding question number 10. My name is Samir.
1 second, Samir. Oh yeah, NVC. Go ahead.
Yeah. After approximately how many weeks or months is the conditional green card mailed to the applicant once the applicant enters the USA?
I do not know. From what I last heard. From what I last heard, it was only a matter of a few weeks, 4 to 6 weeks. However, these periods can vary widely. So I really cannot tell you that this is a line written in stone. It can change, but it's a good idea to follow through with the card production and see where it is.
Okay. One more question, Rajiv ji. With I-151 stamp on the passport, can I-151 stamp be used for work authorization purpose?
Absolutely. The stamp that says processed for I-551. I-551 is the green card itself. Processed for I-51, temporary proof of permanent residence, or some such language. That is as good as a green card. You can travel with it. You can work with it.
Okay. Thank you, Rajiv.
You're welcome. All righty. Let's go to next question. This is a call from either a voice over IP or maybe Skype.
Hi, Rajiv. This is Satish. Question number is a follow-up question from question number 7.
Are you with a friend with a health issue?
Yes, that's correct.
Okay, go ahead, Satish.
Rajiv, actually, I am also from New Jersey. There are two dialers, so you have been disconnecting my call.
Oh, I'm sorry. My apologies. Because
Because when you were answering, that lady, she came in and she was asking question. We completely lost what you have been telling. So I've been writing my answer. Finally, disconnected my call.
I'm so sorry. You have my apologies because I kept thinking, the problem is her case is it has a very long history of almost over a decade. So it's very difficult to make snap judgments. There have been lawsuits, there have been all kinds of things. I explained that I can't really do it in this call. It requires a lot more than I can do. But I thought that she was the one raising the hand.
And
you are from the same.
my relative right now is in the conference from India, Maharashtra. So he has a follow-up question to the answer which you gave last conference call. He's going to ask 2 or 3 questions. Maharashtra, can you pose the question?
Go ahead.
Yeah. Hi, Mr. Rajiv. Yeah. So if my green card expires, after the green card expired, can I still travel to USA using the letter of transport?
The answer is, in my opinion, yes. Please double check with the consulate before any of your papers expire. Okay? Double check with the consulate, make sure they understand what issues you have. They will respond to your email. Try to make it concise. Don't make your emails so long that it will be difficult for them to answer. Make it concise. Ask them these questions. I personally feel entering back into the US before January 30th is a very smart thing. Everything else you do puts your green card up in the air. I do not know how it is going to play out.
Okay. So, and my second question is, can I apply for my fingerprint appointment after the expiry of the green card, or it has to be done before the expiry of the green card?
Are you talking about fingerprinting for renewal of the green card?
Yeah, the appointment for the green card renewal.
Yeah.
Because I won't be able to come to USA before, even if I apply for the fingerprint appointment before the green card expires. And I can only enter USA after the green card expires because of my health issue.
Okay.
So is it okay if I get the fingerprint appointment after it expires?
I don't think we have a choice here. Okay. There are 2 sets of issues. One deals with being able to enter the United States, which is a bigger issue. Okay. Can I enter the US after my green card expires and my re-entry permit expires? And the answer is that depends upon the consulate. So you have to ask them. Another thing you can ask them is whether you should get a travel letter or you should get SB1 visa. Write that down. SB, S as in Sam, B as in boy. SB1 visa. SB1 visa is also called returning resident permit. And returning resident permit is given when somebody has such a situation that they just cannot make it back within a year. Consulate then reviews their case and within 3-4 months issues them a quote-unquote a substitute green card. So you can come in with that SB1 visa basically entitles you to come back to the US and then you get your green card again. So that's one side of the picture. That's the more important one. The actual renewal of a green card. Let me give you an example. Let's say if you were in USA and your green card expired and you were carrying an expired green card for a year, not realizing that it was expired, can you then go and renew it? Of course you can. So renewal is no problem. Entering into USA is your big
re-entry. Oh, okay.
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 Okay. Yeah. So, Mahavar, any other questions?
That's all. Yeah.
Okay. Thank you, Rajiv. Thank you very much for your time. Thank you so much for the explanation.
Guys, you're welcome to send me an email if something else should come up. I will give you a call back. I know you've got enough on your plate. You don't need to worry about immigration issues. I think you'll get your SB1 because if you have health issues of that extent, you should be able to make a case to get the SB1. Okay?
Okay, Rajesh. Sure.
Good luck.
Thank you very much, Raj.
My pleasure. Okay, the last follow-up question, then we'll start with the new questions. Somebody from Campbell, California raised their hand again. Okay, let me just get to New Jersey first. New Jersey, go ahead with your question, please.
Hi, Rajiv. This is Drew here with question 16 for the re-entry permit.
Sir, 1 second. Let me get to 16. Drew, yes, Drew. Go ahead, please.
So from your answer, it sounds like that the re-entry permit is just like an insurance.
Yes.
If I take it
yes.
and stay outside, let's say something happens, I cannot come back. In 6 months, then I lose the continuous residence requirement. But if I come back in 1 or 2 months, I don't lose the continuous residence requirement.
Don't confuse the terminology. Let me explain that to you one more time. Okay?
Sure.
Continuous residency for green card purposes, let me rephrase that. Continuous residency for naturalization does not get affected much by your re-entry permit. So it's not going to help you there.
Okay.
What it does help you with is this. It helps you with the presumption that you are abandoning your green card if you are leaving for a long time. So it just protects your green card. That's all it does. It doesn't do anything more than that. And I think your analogy is very good. This is like an insurance. If you use it, if you have it, you can use it if needed, but you probably won't need it. So then only thing you've lost is the money you spent in the insurance.
Got it. Yeah, the money part is fine. It's the wait part. So if I come back within 6-8 months, I'm good. I can naturalize. That requirement is not broken. But unfortunately, if I don't come back in 6 months, then the requirement is broken. But my green card is preserved.
Well, even there, if the naturalization requirement is this, if you cannot be outside USA for 1 year or more. If you are outside 1 year or more, actually there also the re-entry permit helps you. If you're outside for 1 year without re-entry permit, and let's say you've not lost your green card, you will have to start your 5 years all over again.
Okay.
But if you have re-entry permit, you don't have to start 5 years all over again. You just have to do 4 years and 1 day.
Okay.
So,
that is good to know.
Yeah, so re-entry permit has many advantages. Also, if in any 1 12-month period, your stay outside is less than 1 year, more than 6 months, it does not break your residency for naturalization, as long as you have a good explanation for it.
Got it. So coming in, let's say if I come in, let's say back in 3 months. So what do I show the CBP official? Do I show both my green card and the re-entry permit and let them decide whichever they want to?
Just the green card. Just the green card.
Okay.
If it's less than 6 months, just the green card.
Okay, and if it's longer, show the re-entry permit.
That is correct.
Awesome. All right. Thank you so much, sir.
You're welcome. Good luck. Okay. There was a hand raised from California. California, go ahead, please.
Hi, Rajiv. My question is, I work on H-1B. My visa stamp is set to expire.
I'm sorry. I'm muting you because I haven't invited new questions yet, and you are pretty much the last person who logged in. So I have to invite new questions and go in the order people logged in. Please stand by. I'll be right with you. Folks, any questions, press *5. Any questions? Campbell, California, I have you already, so just stay on the line. Any questions, press *5. New, old, life, law, anything. Okay, 3 new questions. Guys, make sure everybody who has a question has raised their hands. After these 3, I will not answer any more questions. I see there's a lot more than 3 people online right now. Okay, so we'll do these 3 and then we are done. Let's start in the order that you called in. This is a blocked call. I don't know. It could be voice over IP. Sir, ma'am, go ahead, please.
Yes. Hello, sir. This is Sanket from California.
Yes, Sanket.
I asked you my question. I asked you my question on Twitter.
Oh,
so
yes,
by some mistake,
hang on. Let me just get to Twitter. Sanket Patel.
Yes.
Okay, you applied for your OPT EAD and the EAD got lost in the postal service delivery, right?
Yes.
Okay, Sanket, there are a couple of things that I want you to think of. First of all, I do not know of any other way of getting EAD except through reapplying. Okay? So you will have to reapply and explain to USCIS that you're applying for a replacement. I think on the I-765, there is actually a place where you indicate this is a replacement card. Okay? Now here is the good news.
Okay.
When you apply for a replacement card, in a few weeks they'll send you the receipt that you applied for it. You can actually start working with the receipt. It's called the receipt rule.
Okay.
So your action agenda is, if I were you, I would do the following things. I would apply for the replacement card, and on April 1st also, maybe if that's your plan, apply for the H1 also.
Yes, that's the plan.
And I think you'll be fine. You are in status, you just don't have the proof of your status.
Yes, and it takes like few months to get a new card, so I might
you
when should I start working? That was my question. So, thanks a lot.
As soon as you get the receipt, Sanket, no problem.
Okay, thank you so much.
You're welcome. You're welcome. All right, bye-bye.
Thank you.
You're welcome, sir. Okay, last two questions. This one is from Pennsylvania. Pennsylvania, go ahead, please.
Hello, Rajiv ji. So I have a two-part question. One is follow-up from the one that you answered before. So I'm on H-1B. I have I-140 approved from employer A. I switched my job to employer B and got a 3-year extension on my H-1. And they have filed for PERM LC. It's still in pending case. Now I have another job that is from employer C. I would like to transfer my H1 to employer C. Will I get 3-year extension based on my I-140 approved from employer A if it has not been revoked? And is there a way to find out how one can know if the I-140 has been revoked or not?
Easy question first. I don't think you can find out whether the I-140 has been revoked or not. Unfortunately, there is no mechanism for it currently.
Okay.
Only your employer can tell you.
I'm sorry?
Only your employer can tell
you. Okay, I see.
Second, will you get 3 years? Now, here is the problem. USCIS has been inconsistent in these cases. Let's say I got my 3-year extension and I joined the employer, and after 8 months, I want to change employers. Will I get 3 years or will I get 2 years and 4 months? They are inconsistent. Okay. So practical solution, easiest solution. Let's forget about the debate. We are not academicians. You need some benefit. I am a lawyer, not a college professor. Practical approach is very simple. Have the new employer apply for your H1. Do not join them until the H1 is actually approved.
Okay.
Even if the H1 gets approved, it does not take away the old H1. You decide not to go to them because you only got 1 year of H1 extension. You don't have to.
Fair enough.
Okay.
All right. Perfect. Thank you so much, sir.
You're welcome. Good luck. All right, Campbell. I'm so sorry I have to keep cutting you off. I don't think you've done our conference before, so you probably don't know the process. No problem. I'm with you now. Campbell, California, go ahead, please.
So, thank you, no problems. My question is, I'm working on H-1B. My visa stamp, which was from my last employer, not the current employer because I changed the job while being in the US. That visa stamp is set to expire on Feb 1, 2015. I would travel internationally to Brazil for work in the next month, sometime in Feb. So I know that I cannot get back into the US on an expired visa. I don't know if it is a good idea to try stamping in Brazil. That's my first question. Because various countries, maybe they behave differently. The general convention is to go to Canada and get a visa stamp if needed. So do you think I should try getting a stamp in Brazil or I should not do that?
Definitely. We have a lot of clients who come from Brazil or get visa stamping through Brazil because we've got a few clients who have a very large corporate presence in Brazil. Okay, so I do not believe that Brazil is unreasonable beyond what India can be or Canada can be, as far as I know. Okay, so what you do is just to confirm that they have the resources to process third country nationals. You can just send Brazil non-immigrant visa section of the U.S. consulate an email saying, I'm going to be visiting Brazil. I want to apply for an H-1 visa there. Will you entertain the application? And chances are 99.999% that they will. Okay. So, and the downside is, let's say if they deny your application, you can always fly to India from there and then apply in India.
Right.
Okay.
Right. Yeah, that alternative is something that I have, that I can fly to India and then do my stamping over there.
Yeah. The thing is, if they deny you in Brazil, you can still do it.
Oh, if they deny me in Brazil, I can still go to my home country?
Yeah, absolutely. Absolutely. Depending upon the ground of denial. If they deny it and say, oh, this visa is fraudulent, of course, then you got a big problem. But if they deny it on a basis like we can't verify the degree or we can't verify the experience or something like that, you can always reapply. Okay. So, there is no requirement that you have to apply in the same consulate.
Okay. And if I wanted to go to Canada for stamping, the reason I'm trying to avoid that is the whole time spent in first getting a visa for Canada and then traveling there. I was under the impression that if I have a US work permit, H-1B visa stamp, then I may not need a visa for visiting Canada and getting a stamp.
This is an issue of Canadian law, not of US law. But from what I understand, everybody needs a visa stamp.
Right. I mean, I need a visa first of all to visit Canada, and then I'll have to get a H-1B stamp in Canada to get back into the US.
I'm talking about the Canadian visa. Yes, you need a visa to enter Canada. But you can double check with the consulate.
Right.
I am not a Canadian lawyer, so I don't know.
Right, yeah, that's what I also heard when I went. I mean, I found it on the website as well that I would need a visa for Canada. Somehow I was thinking that a H-1B stamp allows me to visit Canada and get a stamp without getting a visa for Canada specifically.
I don't think that's true.
Right. Okay.
All right.
So that clarifies my questions. Thank you.
Good luck.
Thank you.
That ends our call today. I will talk again with you next Thursday, which is whatever that date is, will be shown on our homepage. Thank you for being here and for letting us assist you. Appreciate it. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.